Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trusts and a leading estate planning attorney serving Orange County families for over 25 years. My name is Kevin Rosenquist. Thanks for being here. Today we're going to talk about choosing the right people to carry out your wishes, from trustees to guardians to powers of attorney. These roles come with some serious responsibility. Brian's going to walk us through how to think about those choices, what traits matter most, and some of the common mistakes to avoid. Brian, welcome back.
Thank you, Kevin. Thank you for having me on today.
Yeah, absolutely. It's great to have you on here. It's an interesting topic because, it's like a who do you trust kind of situation, and I mean, this is a big thing that you're trusting them with. So, if someone comes into your office, sits down to create a trust or an estate plan, how important is the decision of who to name as trustee or executor?
I mean, it's critical because, people a lot of times when they come in, we're going to prepare a document, a trust for them. And they think that the trust is just automatically going to be followed. And I always tell people at the end of the day, the trust is a piece of paper. It gives authority to somebody to act, and that person will hopefully do what you've asked. But at the end of the day, a trustee operates with little or no oversight. Meaning nobody's watching what they do. The bank doesn't care what they're doing. The only people the government, for the most part, doesn't care what they're doing. The only people that care what they're doing is the persons who might be harmed if they're not doing what they're supposed to do. And so that's why trust is the number one criteria. I was, someone that you're going to pick somebody that's fair and honest. That's the number one criteria when selecting someone to be a trustee or power of attorney or a healthcare agent.
Aside from trust, are there other qualities or traits that you recommend clients look for?
I mean, I think the number one, after being fair and honest, it's good judgment, because they're going to be acting like you would. And the paperwork can only do so much in terms of providing some guidance. At the end of the day, people are exercising judgment. What do they think is in the best interest of whoever they're doing something on behalf of? And it might be you. And because a lot of times people think, I'll put this person in charge. I trust them if I'm not here, to deal with my heirs, as an example. Well, I remind them, this same person, they also might be in charge on your behalf because you're alive but incapacitated. And so now they're doing things for you. So you can't, it's not just trusting them to take care of your heirs. It's you trusting them to take care of you. And so, beyond being fair and honest, having good judgment, because a lot of things are judgment calls.
Absolutely. And then, I think there's probably a tendency out there for people, if they're going to be talking about their kids, to just name the eldest kid to be the trustee. Is that something you see often? And is that a risky way to go, just to automatically do that?
I don't know if it's risky. I mean, we do see it quite a bit. But yeah, I wouldn't necessarily choose, whoever's going to be in charge because of the oldest child.
Mm-hmm.
At the end of the day, you have to look at, and this is where I have my discussion with the client is, what is the likely scenario? How will this likely play out? Okay, because it's one thing to just put, 3 names on a piece of paper. What people don't really think through is, okay, something happens to me, this person's now in charge, and, politically, how's that going to work within the family? Okay, and, to some extent, you don't have to be too concerned about the political side if you don't want to be. But I always tell people, as an example, you might have, there might be a pretty good age gap between the children. And so there's a potential that one child might be in charge because one of the other children are young adults, that, one child might be in charge on behalf of the other child, the older one on behalf of the younger. And I said, that's fine. Again, there's no legal problem with that. The issue is politically is that there's the potential there to cause a rift between the children, because now the older child's in the position where they may have to say no to certain requests of the younger child, and over money, which, in the long term, you ask the parents, is that worth the risk?
Mm-hmm.
Is there a concern there? And it's not even saying, not putting the oldest child in charge do you want to put the oldest child in charge to say no, and with the potential, or, I've seen it the other way around, put the younger child in charge, where they have the potential to ruin relationships for the rest of their lives over money, which, if you ask the parent what's more important to you, that, worst case, the kid gets the money early and they blow it, versus, the relationship between the 2 siblings is ruined forever. Sometimes it's more about it is more important about the money, but most of the time it's more important about the relationships. And those are things, that's the discussions we have with our clients. That's not a legal issue. Those are the practical political issues that need to be discussed when setting up estate plan. And the biggest political issue is selecting the trustee.
Yeah, I could see. I know some people who I could see that being a problem, butting head. Like it's just it's natural, I suppose, in a lot of situations.
Yeah, and with that being said, the alternative is, some people say, well, put both of them in charge, and again, that's not necessarily a solution, because now
Right.
again, they still have to agree, and now they don't agree, and at least if you have one person in charge, the buck stops with them. And unless they're being patently unfair or doing something illegal, the other people don't have, they don't have a legal complaint, at least. But again, those are the things that, having that good judgment, how to do things, because the trustee is given a great deal of latitude, especially when, usually most people, if something happens to you, they're dividing up a pot of assets. And it's not the trustee, typically, if everything's being divided, let's say equally, let's say there's 3 kids, their job is not to split every asset into 1/3 and give, like I said, if there's a real estate, give each person 1/3. Their job is to give each person 1/3 of the total assets. And the then acting trustee's job is to figure out how to allocate those assets within each person's bucket. But they don't have to have 1/3 of every asset. They just need to have, if there's $3 million worth of stuff, each kid's supposed to get $1 million worth of stuff. Now, a good trustee, the judgment they exercise is, okay, I'm going to give them the assets that make the most sense, and hopefully it keeps most everybody everybody happy. I always see path of least resistance. Like example, if one kid's actually living in one of the houses that the parents own, and that house falls within that child's share, then why not give them the house? Even if it's not specified, well, that seems to make most sense. That seems to be the path of least resistance. So that's exercising good judgment as far as, not only just, how to spend money on behalf of somebody, but when it comes to dividing up the assets, which assets to give to who.
What about when choosing a guardian to take care of minor children if the need should arise? What kind of traits, what kind of aspects should people consider?
I mean, and so that's a slightly different conversation than the trustee or power of attorney. So the trustee, they're in charge of money, financial and legal issues. Guardian, they're in charge of your kids. And for those of us, I believe you have a minor child as well, like I do. The single most important thing we're going to do as part of our estate plan is nominate a guardian in our will in this case. The guardian is, we're telling a judge, if they have a choice, this is who we want to be the guardian of our children, the person who physically, the person who would take physical custody of our children. And that's probably the single most important part of our planning, because you want to have a say. Because
Right.
if you don't have any documents, then you have no say. And now, because a judge, ultimately, they choose amongst the people that apply to be the guardian, which means, if you have no input, you don't have any nomination, that means the judge has no input from you. They're just going to go on whatever somebody else tells them as far as who should be the guardian. And they have no input from you. And obviously the guardians, who do you trust to take care of the kids? And that might be slightly different. Quite frequently it is the same person you trust to be in charge of the money. But, we have a handful, a fair number of our clients will, choose somebody else to be the potential guardian. They may be good caretakers. Maybe they're not the best with managing money, so that's why they're fine being the guardians, but may not necessarily they may or may not want them to be the trustees in that case.
You mentioned before about like the dangers of naming co-trustees or co-agents. I'd like to unpack that a little bit more. Are there pros and cons to taking that approach?
Yeah, I mean, it's definitely pros and cons. And I don't tell my clients to do one or not to do one.
Sure.
Usually, it's all about the people. How well do they get along? Obviously, the pro of having a co-trustee is, division of labor, check and balance. And that's what when I tell my clients, those are the, if you're going to appoint a co-trustees, that's the reason to do it. Check and balance, division of labor. Do not appoint co-trustees because you want different perspectives. Different perspectives is terrible.
Yeah.
Because that means they will not agree, because the requisite, even if you only require one signature, they still have to agree on actions. And if they have a philosophical difference, especially fundamental, could be religious, anything like that, differences, that can cause big issues.
Absolutely.
And so that's a concern with having co-trustees, is they do need to agree, and naming co-trustees is the most likely thing that'll lead to some sort of litigation down the road if it's going to be an ongoing trust. Now, on the other hand, again, people, if they get along, typically siblings, hopefully they get along and they think alike. And again, it's more of a division of labor and a check and balance. I think it's fine to do, co-trustees. And I always tell people, I don't know anybody, so I have no idea how they interact. And the issue there is sometimes, a lot of times the people putting the trust together, they don't know how those people would interact,
Right.
especially if they're on different sides of the family, that don't interact much. I usually, that's if there is a case, that's most commonly, people want to do that out of fairness. But I always tell people, ultimately you choose somebody who will be fair. And I think that's better than, choosing co-trustees from people that you have no idea how well they would work together. And also, the other factor in choosing co-trustees is what are we talking about in terms of the assets, in terms of, is this just a straightforward, it's just money? Something happens to you, $1 million split up amongst two people, 500,000 each. Okay, that's fine. That's not that hard. There's not a lot of decisions to be made there. So co-trustee is probably not as big an issue versus, money's going to be held in trust potentially for young children, or that might be, or lifetime, for special needs, or somebody's disabled. Now that is a long period of time, and people, there's a lot of decisions to make and a lot of judgment calls. And so that's where there's just a lot more opportunity for people to disagree when there's a lot of judgment calls. So that's usually what we try to recommend doing, sole trustees if you can.
Obviously, circumstances change, life changes. How difficult is it to change the people that you appoint after the fact?
It's just an amendment. I mean, you're,
Oh, okay.
you're amending and or replacing a series of documents. So regarding the trust, you're amending the trust, and at least if you're changing trustees, you're almost always amending the trust, doing a new certification of trust, and updating the power of attorneys. And if that same person that you're changing is also in the healthcare directives, you may be updating the healthcare directives. And then obviously if that person is also a guardian, then maybe you're changing that as well. So as I always tell people, the change in people of your agents is what's going to be, require the most extensive amount of changes. But everything's changeable. Almost never are you unable to change who the backup trustees are.
What are the dangers, I guess, of choosing the wrong person, as you've seen it over your 25 years?
Well, like I said, the big issue with, the trustee, basically, I always tell people, a trustee has full authority to do whatever they want. They may not have the right to do whatever they want, but they have a full authority. In other words, again, like the biggest issue, the government, the banks, they don't care what they do with the money. That's none of their business. I always tell people the trustee is like a treasurer of a company. Okay. Can they, my clients always ask, can they steal from the trust? They say, well, can a treasurer steal from a company? Yeah. They have access to a checkbook. They can write a check. They can write a check to themselves, take that money, go to Las Vegas and blow it. Okay. Yes, they can get in trouble. They go to jail. They get sued, but that's after the fact. Okay. You can't stop a trustee from doing anything until afterwards. Right. And so that is, that's the number one potential issue with a trustee is, yes, they have full access to everything. And I always tell people a trustee can do anything until someone decides to sue them, but that's after the fact. That's after something's happened. There's no pre-crime here. There's nothing stopping anybody from doing something. You can't stop anybody doing it before they've done it. And so you are trusting your trustee to do what's right. And, and also depending on how your beneficiaries are, especially if they're young children or a disabled person, their ability to protect themselves is fairly limited. It's another thing, it's one thing with an adult beneficiary who at least, they can see an accounting, they may be able to see what's happening. Other people, they'll have no ability to see what's happening. And thus, whatever it is, if something is happening that's not right, it could be years or decades later.
Yeah.
And then it's too late.
Is there ever a situation where you recommend like a professional trustee, a private fiduciary, or a trust company?
I mean, we have this come up quite a bit. We have clients who have limited family members,
Sure.
who are alive, or more importantly, that they trust.
Oh yeah, I was going to say we're trustworthy.
Or it just sometimes they need a third party, and again, this might not necessarily be a fiduciary or a bank, where they need a third party that's not one of the kids, that's not somebody who has a vested interest to be in charge. But frequently, people don't want to burden people with doing that. It's one thing to burden your kids to do it. Well, somebody's got to do it if they want their money.
Yeah, that's true.
if there's a likelihood that choosing one of the kids is going to cause a political issue between the other kids, and you just don't want them to have to worry about that, or they're just not, maybe just not, they're real busy, or they, for whatever reason they wouldn't be good trustees, then yes, we're looking at third party, either a professional fiduciary, which is a private firm that you would hire, usually a person or persons that you would hire to be the trustees, or if you have enough financial assets, you can hire a bank or financial institution to serve as what we call a corporate trustee. Obviously, the advantage of hiring them is they're a neutral third party.
Sure.
They'll do what in this case, they are more likely to follow exactly what you say in your document, for better or for worse. But you can trust them. You're basically, as people say, I always tell people the number one criteria is trust. Well, in this case, you're buying trust. Mm-hmm. With a bank, now the downside of having a corporate trustee is, yes, you can trust them. They're going to be around. The issue there, though, is you're now dealing with a monolithic, impersonal, and I don't know many people that have really good relationships with their banks. Well, this is the person that's going to be in charge. Some random person at the bank is going to be in charge of your trust. Right. And yes, again, you can trust them because they, the bank is going to make sure they do what they're supposed to do. But it is impersonal, and they will have more of a formula how they do things. Again, sometimes formula is good, sometimes formula is not as good.
Sure.
Okay, versus if you pick a individual, they have more flexibility, which is again good and bad.
Right.
Private fiduciary is kind of for those people. The one issue I tell people, corporate trustee, that sounds fine for if they're in charge on behalf of your heirs. The corporate trustee may not be an ideal situation if they're in charge of you, your money as your power of attorney or what have you. And that's where, alternative, and or if you have a smaller estate, having a private fiduciary, this is where you're hiring an individual. And in this case, you do get to meet the person. You get to meet their firm and see how they work, what their plans are. Of course, it is, you are now dealing with on the trust end. You are dealing a little bit with, well, now you are trusting a person, and it's now an individual or small firm, which aren't held necessarily. Well, they're held to the same standards. There isn't the same redundancies and backups and things like that when you have a private fiduciary firm in charge. But you get to meet them, and again, especially if they're in charge on your behalf, you know who they are. And a lot of times these are, the fiduciaries they are family organizations where the business is being passed on from generation to generation.
Right. That makes sense. Yeah. All right. Well, your estate plan is only as strong as the people you trust to carry it out. If you're not sure who to name, or you just want to make sure choices are still a good fit and just want more information, Brian and his team can walk you through your options and help you make the right call. Visit ocwillsandtrusts.com to learn more or to schedule a time to talk. And don't forget to subscribe to our channel. Leave us a review. We greatly appreciate it. Brian, always great having you here. Thanks so much for all the insight.
All right. Thank you, Kevin. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.